Please. Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. I am Justice Vicki Henry. Welcome to the November 1st, 2024 sitting of the Appeals Court. My pronouns are she, her. You are welcome to share your pronouns or not as you see fit. I am delighted today to be joined on my right by Justice Sachs and on my left by Justice Singh. In the Appeals Court, we have 15 minutes per side. For better or for worse, we have no rebuttal. And if, when you step up, make sure you've adjusted the microphone so we get a good recording, because sometimes we do like to go back later. During the argument today, you may see some of us looking at our giant iPads. That's because we try to be fairly paperless here, and all of our materials are on those devices, so we're just looking at your briefs, et cetera. And with that, we'll begin. The first case this morning is 2023 P 1251 Commonwealth versus Silva.
Good morning, members of the panel. My name is Sarah LaRoche. I represent Alexis Silva in this appeal. May it please the court. The Commonwealth erred at trial in admitting identifications of the defendant from two different sequences of surveillance video or surveillance images. The error was preserved by the motion in limine that was litigated prior to trial.
Can I stop you there?
You may.
The motion was allowed.
Yes.
Then the Commonwealth introduced evidence in what you say was a violation of the motion ruling. Wasn't it incumbent on you to object then? The Grady case you rely on is where the motion in limine was denied before trial. And the judge thus took a position that the evidence could come in, so it was more or less futile to object again at trial when it did come in. This is the reverse.
Your Honor, even if that is the case and the standard of review is that this is not preserved error that we're dealing with here, the prejudice that flowed from the admission of those two the identification of the defendant in those two portions of surveillance video that were really crucial here, that prejudice is enough to require reversal. And that's really what I wanted to focus on with all of you this morning.
So could I want to confirm what the two sequences of videos are. One
Absolutely.
of them seems to be him parking and walking into his own home.
That's correct.
Okay, well, but I wasn't totally clear what the other one was.
Okay, so just to sort of lay it out for you, the way that I see the case, there are sort of three sequences of surveillance video which matter. The first is the surveillance of the shooting itself, in which we cannot see any people in the car, and in fact you can't see the license plate on the car, and that's what really led to the Commonwealth needing to reach back for other surveillance and reach forward for other surveillance, because we can't discern anything about that vehicle, who's in the vehicle, the license plate of the vehicle. The second sequence...
Before you go to the second one, do you
Yes.
happen to know the exhibit number of that first one? Because we've gotten, I think, all of the...
So it's three different exhibit numbers, Your Honor, 60 to 62.
Okay, great.
So that's the brick and wood surveillance. The second sequence is exhibit 68. And that is the sequence of video 5 minutes approximately after the shooting, which is captured by a surveillance camera in the area of 29 Bank Street. And then the third sequence of video, which I say matters, is the following day, between 11:45 a.m. and 3 p.m. when Perez is, as the Commonwealth says, sitting on the white Lexus. So he's there, he's observing the white Lexus, and he makes other observations.
And that's exhibit,
Oh, that's Exhibit 50, Your Honor.
thank you.
Yes. So I want to note, and this is a phrase that I did not include in my brief, and I think it's really important. In the Commonwealth's opening, the way that the prosecutor first tells the jury about this case, he says, "Jury, at first this seemed like the perfect crime because we have no eyewitness, because we have no one who can describe the car. So, jury, you are going to have to look, among other things, you will have to look at surveillance video in order to connect the dots between this white Lexus in Brickenwood and the defendant and his home at 29 Bank Street." It was not a matter of direct evidence of an eyewitness who was able to put the defendant in that vehicle at the place of the shooting, and not just the defendant in the vehicle, but the defendant alone in the vehicle. So the prosecutor said in opening, you need to look, and you will know by looking at this surveillance video that we have for you, you will know that it is the defendant, Alexis Silva, who did this.
Right, but so let's start with the last video it seems like you're unhappy because the police officer said, this is Silva walking from his car to the house. And what should have happened is that he should have said, this is a true and correct video of what I saw that day. And then he should have separately said, that's the defendant, that's the guy I saw. And then the jury should have put those two together.
That's correct, Your Honor.
Right, but why is that not,
As
why is that a
Wordsworth-
substantial?
As Wordsworth tells us, there is an imprimatur of authority when you have a prosecution witness, when you have a cop, or when you have a prosecutor in opening statement pointing at a video 5 minutes after the shooting and telling the jury, that's the defendant getting out of his car.
I thought Justice Henry was asking about the surveillance video the day after, where the officer was a witness to the defendant coming into his house, saw the defendant up close, evidently, I haven't seen the videos yet, but evidently more closely than the videos show him, was, snapped a photo of him with the officer's phone, I think, as he was coming by the house, by the officer's car. Didn't he have exposure to the defendant that the jury did not have at that time, and he could confirm that the person going into the house was the same person who just walked past him in his car, the defendant?
The case is, this does not rise to the level of the kind of special familiarity that the cases talk about. He saw the defendant by my count, 5 or 6 times over the period of 3 hours. Yeah, he looked, he was watching him. He was really...
Right, he was really watching him. This wasn't a casual exposure that he, passed by him on the street without knowing who he was. He was assigned to watch this house and this car and what happened there, and he saw the defendant.
I submit it does not rise to the level of special familiarity in the cases. He does not have this relationship that goes back. Yes, he passed by. I absolutely agree. He could have authenticated that video. He could have said, yes, that's an accurate representation of what I saw. But it matters when we have a prosecution witness 14 times pointing at images and saying that's the defendant. It matters when it was a matter of inference for the jury to say that it was the defendant alone in the car. It matters that the prosecutor and the prosecution witness pointed at surveillance video and made these identifications that neither of them should have made, and connected the dots in that way for the jury.
Counsel, excuse me, when you say that the prosecutor should not have stated that, I mean, the prosecutor was simply stating what he expected the evidence to be able to show. So that was proper, correct?
He could have said, jury, you will be able to infer that the defendant came home 5 minutes after the shooting. He got out of his car and he ran into the house. That is different from first saying to the jury, I'm going to show you in a moment some video. This is like Wordsworth, the fronting. I'm going to show you some video, and you're going to see the defendant in that video. That is different. That is different than saying there will be inferences. Nobody else in the case looks at that video and says anything at all. It was a matter of inference. It was a fact to be found by the jury based on all of the evidence in the case. It was not a fact to be handed to the jury by the prosecutor in opening statement.
So, it would be improper for the prosecutor to say the evidence will show that the defendant got in this car, and to tell the story of the crime and frame it in terms of this is what the evidence will show.
But that's not what he did. He put a surveillance video up on a TV, I'm assuming, or a projector of some sort. And in the first minutes of the case, he said, okay, this was a perfect crime, but you're going to know that it was him because I am pointing at this video and I'm telling you that's your guy. That's different. And if I could, if there are no more questions sort of on that piece, I'd love to just say two more things about the prejudice. The first thing that I would like to say is that the verdict itself of murder 2 reflects some doubt. Now, we don't know what was driving that doubt on the part of the jury. It is not a conviction for murder 1. The jury had doubt about the Commonwealth's case. And I submit.
Why isn't it just doubt that there was premeditation or extreme cruelty and atrocity? Why is there doubt about anything else?
We don't know.
But why would you infer doubt about anything else from the fact that it was a second-degree verdict rather than first?
I infer that there was doubt, and I don't know what that doubt was. One piece or one witness who the jury may have had doubt about is a witness I believe my brother will talk about, Tara Duarte. And again, this is not specifically addressed in my brief, but the defense attorney was successful in showing bias on the part of Duarte, and he was successful in showing that perhaps she was not a credible witness. She said, I met with the prosecution as many as 10 times. They pressured me. They threatened me. I told them what I had to tell them. Okay? She also is really sort of minimizing about how much she drank that night. She says that she was with the defendant's girlfriend for 9 hours at 5 locations, and she really minimizes how much she was drinking. And in one case, she gives some contradictory testimony about how much she drank in a particular location. The jury had reason to doubt and question Tara Duarte. And Tara Duarte, the Commonwealth will say, is so important in establishing that the defendant was alone in that car and that he alone was the shooter. I don't know, and we cannot know, what the source of the doubt was. We know that there was some doubt, and my argument is that without those two identifications or identifications of the defendant that were improper from those two sequences of surveillance video, there is a question here about whether or not the verdict would have been the same. If there are no further questions on argument one, I'll address quickly the second argument. The Commonwealth.
Could you just
Yes.
sum up why this is a substantial risk of a miscarriage of justice?
Because it was a matter of inference that the defendant was alone in the car and that he shot. The conclusion that he was alone in the car and shot required a connecting of dots. And the connecting of those dots was facilitated by the improper identifications of the defendant in surveillance video. Quickly, on the second argument, the Commonwealth concedes that the prosecutor shouldn't have asked. He shouldn't have asked about the witnesses, the girlfriend of the defendant's invocation of her Fifth Amendment rights. The Commonwealth seems to say it wasn't prosecutorial misconduct. It was. The prosecutor absolutely exploited the invocation. He mentioned it with the witness multiple times.
May I ask?
Yes.
The Fisher case says, when a witness refuses to answer questions in front of the jury, then we look at whether the prosecutors unfairly exploited the matter and whether the inferences from the witness's refusal to answer may have added critical weight to the prosecution's case. Here, the witness wasn't refusing to answer. She was answering in a manner that, at least from the cold transcript, looks very evasive, and that's what hurt the defendant's case.
That's correct, Your Honor. I see that I'm out of time. Would you like me to answer?
Please. So those cases about invoking seem inapplicable because the focus here was not on the fact that she had previously invoked her Fifth Amendment right, but what she was immunized and then she testified fully. And it was the inferences from the testimony that I think were damaging.
I think that's right. I mean, but the Hesketh case says there is no inference to be drawn from a witness's invocation. I don't know that Hesketh says that has to be an invocation in front of the jury, simply that we can't have. And Troche really talks about how important and how bad this is, right? There is no inference to be drawn, and certainly here we have on the record very clearly that the prosecutor sought an inference to be drawn. I will otherwise rest on my briefs. Thank you.
Thank you.
Good morning. May it please the court. Stephen Nato on behalf of the Commonwealth. Your Honors, dealing with the first issue, which is the video testimony. Obviously, as you know from our brief, we disagree with the characterization of the testimony in this case as opinion testimony. Trooper Perez, for his part, was present for each of the images that he identified the defendant in.
Right, but let's take them in the beginning, right? Starting, I mean, this was sloppy, and if we don't make the Commonwealth do it right, then how are we ever going to get the Commonwealth to do it right? That puzzles me all the time when we just wave our hand and say no substantial risk. Because when you look at the opening, she's right. They say, play the first clip. I'm going to direct your attention to the video that's in front of you. This is now the third pass that this defendant made. There's no, like, you're going to be able to infer. This is for you to decide. It's just, they're just told. And, I mean, do you think that was right? Shouldn't the prosecutor have said, you will be able to infer this was the defendant and he was alone?
He perhaps could have avoided, this discussion today with a, finer point of words, but I don't think there's an impropriety there. I think within context, it's clearly understood that here's the expectation of what the evidence will show, and of course, the jury were instructed that the opening statements are not evidence. And I think, in fairness to the prosecutor, this is a very strong case on identification. taken all together. And so that identification was quite decisively established in this case by both the videos, by, again, Trooper Perez, who witnessed the defendant himself, and by Ms. Duarte and Ms. Rivera, who were able to place the defendant in the white Lexus, most notably at the time of the shooting at Brickenwood. So I think that was a absolutely fair comment by the prosecutor in opening. Again, maybe could have been more precise in his language, but the evidence did bear out his expectation and supported that statement in opening. And then, of course, when sort of the next phase, when Trooper Perez is testifying, again, he was there, and I think Pai Tu Hiang is a case that's sort of on point. This is not an opinion. This is just, yep, that's the scene I was at. His cruiser is visible in the video itself, and he describes, I saw the defendant, even before he makes IDs based on the video, I saw the defendant making these movements, walking this way. I took my own photos of him. I took my own video of him, and then showing the video, yes, this is the scene. And
Is she right that technically he should have said, this video is a true and accurate depiction of what I saw that day, and then, period, and then he should have said, and that person sitting, the defendant wearing the whatever suit, it was the person I saw that day, and then let the jury put those two together?
I don't think that's necessary. Again, because it's based on his observation, I think can sort of describe.
Well, but usually we say you have to have a familiarity to identify someone from a video. We don't usually.
Well, and that's fair, but I think that's typically done when the witness was not an eyewitness to what's actually on the recording. And so that's when you get into special familiarity, like a personal relationship, a familial relationship, and even as to that point, even if I do accept that framing, the basis for the special familiarity, again, is that he was there and saw it and the jury was not, those particular events. Turning then briefly to the Trooper Donovan's and Mr. Rissett's testimony. Again, not really opinion testimony involved there, merely sort of testifying to objective features of the video that they viewed, helping to sort of explain why these videos were captured, from the particular locations, the investigative significance of them, and then, of course, for Mr. Rissett, why they were arranged in a particular manner in the compilation. So all told, I think no error in any of the video testimony or statement in opening, and certainly, again, I believe very strong case on ID, so no, even if it were preserved, no prejudice to the defendant. Turning then to the assertion of the Fifth Amendment privilege that was elicited, again, as we conceded under Troche, it was improper, called solely for the purpose to assert their fifth.
Is Troche an immunity case?
I'm sorry?
Is Troche an immunity case?
Well,
where the
witness in Troche had been immunized. And at least the context I got from the decision was that he was asked about asserting the fifth in the context of questioning about the immunity, but that they don't go in Troche onto the impact of it because it was reversed on other grounds. So as I read Troche, I do think we concede error.
What about Fisher?
Well, Fisher stands for, as I recall, that not every assertion of privilege requires reversal, which is true of, I think, all errors. The defendant's not entitled to a perfect trial, just a fair one, and any error, unless it's structural, does not entitle a defendant to automatic reversal. But here, it's clear the prosecutor was trying to develop the circumstances around the grant of immunity, and that at least was proper. It was not unduly exploited then in closing. In fact, immunity and the fifth not mentioned at all. And Ms. Rivera, her testimony referenced twice in a closing that was more than 20 pages long.
Counsel here suggested that the prosecutor was definitely trying to have the jury draw a particular inference. What was the point here? What was that inference?
I mean, certainly the prosecutor was trying to show that she was not credible. And I think, again, that goes sort of all the circumstances why he wanted to get into it around.
Putting on a witness to say that witness is not credible.
I mean, I think, yes, I think she was helpful to a certain extent, but based on her demeanor, she was able to corroborate key points of Ms. Duarte's testimony, so that helped make the positive case for the Commonwealth. But then, when she did testify, she was inconsistent. She appeared to be, I would suggest it's clear on the record, she appeared to be feigning memory loss even then. And so that was an acceptable inference to argue, again, based on her testimony and not based solely on the fifth issue. And again, even conceding the error, very, very strong case for the Commonwealth, even Ms. Rivera aside, her assertion of the fifth aside, and again, where it was not exploited in any way in the closing argument, there was no substantial risk of miscarriage of justice or prejudice to the defendant.
So, I mean, basically, the defendant is arguing, and I'm looking at pages 43 and 44 of the blue brief, that the prosecutor, their motive was so that the jury would draw the inference that the witness previously lied to protect the defendant and that she was continuing to lie at the trial for the same reason. I mean, this is actually a quote from the transcript that she, being the witness, actually doing everything for the defense that she can.
I mean, I think if a witness granted immunity had lied at the grand jury, that prior inconsistent statements, prior lies, are fodder for evaluating the credibility of a witness. Again, should not have been gotten at by way of, the fifth. It should have been stayed away from. But on balance, I think proper inference, again, based on these circumstances.
May I ask, do you agree with the defendant that the errors regarding the video or claimed errors were preserved? Or do you think that they were waived in light of the failure to object after the motion?
I think they were waived, and again, that's partially based on, we don't agree that this was opinion testimony as to the videos, so it would not have been covered by it, and...
Wait, you're saying that the testimony was permissible under the motion in limine ruling?
I'm sorry, that it was permissible?
Yes.
Yes. I think it was consistent with the motion, again, because it was not opinion testimony. Again, the Trooper Perez's testimony was based on his own observations.
Right. What about the narration of the other, the compilation video, I think, by the other
again,
officer?
I think not opinion based on their observations of what's depicted in the video and why they either collected them from those places, and I think that's Chin and...
Do they have any special familiarity that permits them to opine on what the compilation shows? Even explain to the jury on what the compilation shows. Why can't the jury see that for itself?
Well, I think that is covered in Barboza, that it's interpretive testimony, that essentially you just gave a compilation to them without sort of contextualizing. It may be hard to
you can say, this is was it Malden Street in Brickenwood, and this is coming south on Rockdale Avenue or something, and this is from the neighbors near Bank Street at such and such a time. That kind of information about what the video is fine, but saying, and here you're going to see the car, you're going to see 3 flashes or 2 flashes.
Yep.
Isn't that explaining to the jury what the jury could easily conclude or not for itself?
I think perhaps, but it's also, and again, under Chin and Barboza, it hasn't been characterized as opinion testimony, that, maybe as these, compilations get more advanced with the maps, they may be easier to understand, but even still, as to Mr. Rissett's testimony, it kind of helps explain why they're put in these order, and Trooper Donovan, I think, is justified in a little more detailed description of which way the target vehicle is traveling, because it explains why he then proceeds to a next location to search for video there and then recover.
Why is that relevant? Why is the course of the investigation relevant?
Because it shores up, well, first of all, it helps, I think, establish the identity, that we do get a clean sort of track of the defendant.
Okay, but why do you have to say, why can't the officer just say, okay, here's from, and even with a map, here's at Brickenwood, here's at the, coming south on Rockdale, here is Malden Street, here is Bank Street, without having to say, well, because we saw the defendant, well, they didn't say that in the narrations, because we saw the Lexus going south, then we looked at the next camera. We searched the next neighborhood. Well, why is the course of the investigation relevant? Well, there was no real Bowden defense here. This was just, why does the jury need to know that?
Well, perhaps because not putting that forth would create the opening for a Bowden defense, which is not an affirmative defense, but rather...
You can't anticipatorily put on, rebut a Bowden defense, can you? Unless you really know it's in the case?
Well, I think we can always show the fullness of a police investigation, but where, again, Bowden is not a affirmative defense, but one that is, the defense may argue based on lapses in the evidence, lapses in the investigation. So had that not come out, and again, arguably we could have kept that gunpowder dry until the defendant perhaps suggested it and then moved for a rebuttal case, but I think not necessary. And again, under Barboza and Chin, I think still a proper procedure was employed in this case. I do see I'm running low.
You are, but you confused me. I was with you and then I lost you. So you said, I thought at one point you said this was opinion testimony and permissible under the ruling on the motion in limine, but then I heard you say it was not opinion. So, and the answer may differ.
Yes, sorry from...
Yeah.
I think it is not opinion testimony.
Opinion, okay.
And thus was not covered by the motion in limine.
It was not.
It was not covered by the motion in limine, which was only dealing with opinion testimony. So not preserved.
Okay, not preserved.
Yes.
All right.
I apologize.
Is there anything you'd like to say on that, the firearms issue, the last issue?
I'm sorry?
Is there anything you'd like to say on the firearms issue?
Well, only that I know that exact issue, I think, is before the SJC now, so they will speak on it clearly. But I do think, and again, it's kind of unpublished decisions from this court, from panels of this court coming out in that interim period that were essentially saying, we have no power to overturn, the licensing scheme or the allocation of proof in this case because the law from the SJC remains what it is. And so I think if, that is the statements coming out of this court, I think the trial court would be under the same impression that Bruin did not change the allocation of proof in firearm charges. Obviously incorrectly, but I think for that reason, we should be permitted to retry that charge.
Do you know the name of the case you're referencing in the SJC?
At the SJC, not off the top of my head, I apologize,
Crowder?
but it is listed.
Crowder?
Footnote there, yes.
Crowder, okay.
Yes, thank you very much.
I just wanted to make sure everybody was on the same page.
Do we need to decide that in this case, that particular issue?
Well, certainly not as to to deal with the homicide conviction itself, but as to, I think, it wouldn't make sense for the court to decide this prior to the SJC weighing in. They'll decisively say so either way. If there's nothing else, I'll leave it there.
Thank you.
Thank you very much. Well argued. Our next case today is 2023-P-209 Commonwealth versus Class.
Good morning, Your Honors. May it please the Court. Ashley Allen on behalf of the defendant appellant, Mr. David Class. There are 4 issues raised in the brief on appeal. 2 of those issues deal with the warrantless seizure of a package that was delivered to a home, and the other 2 issues deal with the wiretap warrant and whether that was a valid wiretap warrant. Unless the Court has a different preference, I'm going to start with the wiretap warrant. I think it's more lengthy, so I want to get through it. So here, there were numerous misstatements in the wiretap warrant that were necessary for probable cause. Commonwealth will say that some of those things were waived. Just to address that briefly before I get into the argument, there was a omnibus, there was lots of pleadings in this case. There was an omnibus motion to suppress. There was a memorandum submitted in support of that. There was an amended motion. There was a second amended motion. There was a motion for reconsideration. There was an interlocutory appeal. And then it was eventually returned back to the court to have a hearing on the warrantless seizure of the package. So all of the issues, all of the falsehoods that were raised were raised either in the omnibus motion to suppress. The trial attorney didn't specifically, he could have been better about specifically stating each misstatement, but he generalized them in this is false, that's false. There was no partnership between David Class and Vito Resto. There was no in the 2009 case and 2000.
So and I'll just commend charts to all parties, especially when you've got like 10 statements like we have here. So the first thing I did was put all of your statements into a chart, and then I went through and I mapped whether or not the Commonwealth responded. So the Commonwealth says that you did not raise below anywhere that the CS, the confidential source, was given $1,600 and paid Class the debt owed. So do you know where that is?
Specifically raised in the motion for reconsideration. The first judge had denied it without a hearing the seizure portion of the warrantless seizure portion. And when they remanded back to the trial, it wasn't on the wiretap
As
stuff.
fun as I like puzzles, do you happen to have a record site for that?
So I inadvertently did not include the motion for reconsideration. It was transmitted.
So we don't have it?
It's not in my appendix. It was transmitted on appeal in the assembly of the record. This court, through Rule 18, can still consider that, the motion for reconsideration. Or I can also file a motion to amend my appendix to include the motion for reconsideration. It was an inadvertent omission of the motion for reconsideration. There was a lot of pleadings pertaining to this.
But you say we have it in the assembly.
It is in the assembly,
Okay, that's
absolutely.
fine. So the Commonwealth says, even if we took out the statements you claim were false and we added in the statements you claimed were omitted, there was still probable cause to issue the wiretap warrant. What do you say to that?
So they point to, and I'll list what they say is the probable cause. They say the training and experience of police officers, which in every case is present. They point to my client's criminal history. One of those issues on the misstatement is one of the facts about criminal history that they said in the 2009-2010 case, which is also fairly old.
But did that have to do with why a case was dismissed?
So it had two things. It did have why the case was dismissed, which was insufficient probable cause, which is very different from evidence tampering. I think that there's in
The co-defendant's case was dismissed based on the
right.
Buchan.
And his case was dismissed because there wasn't probable cause presented, and so.
But in the end, it was dismissed.
It was dismissed, but it was.
It reflects accurately.
As
to the record.
The final conclusion that it was dismissed, but there's a difference between it being dismissed based on no probable cause, which is not a very high standard. And then separately, there's other statements in that paragraph that are false. So he says that he was overheard negotiating for kilogram quantities of cocaine, and in that investigation, he was identified as a high-level cocaine distributor and negotiating for the purchase of kilogram quantities of cocaine from Resto, who is the other person who's targeted in this investigation. So it matters because we're now establishing since 2009 a relationship between these two men. It goes to the organized crime portion of the wiretap statute and establishing that they're in business together and they've been in business together since 2009. That wasn't true. And so the Commonwealth says that this was not sufficiently raised as a misrepresentation. We didn't prove that it was false because it was only based on the affidavit of Mr. Class. It was also supported by the pleadings in the 2009 case that said that the case was dismissed based for no probable cause. And the alternative. And
But were those before this judge?
yes.
Okay.
And also, the question becomes is, in order to get.
Okay, so, because we have in the record, and I saw it and I was like, why is this here? It's from the 2009 case, so that's why you're telling us it was, and then isn't there like some side margin order that all the trial court judges love to write in their handwriting up the side and you can't read it?
That you can't read it,
Yeah,
yes.
so did y'all type it up for us as our rules ask you to do?
I can't read it as well.
You can't read it as well.
I did try to decipher what it said.
Oh, yeah, I couldn't.
Yeah, I could not. I think that's possibly why there was an affidavit submitted by the defendant that said, but on the record, it says that, and we submitted the docket, it says that it was dismissed for lack of probable cause. So going back to the standard for Frank's hearing and proving that there's a substantial preliminary showing, it's still less than preponderance of the evidence. So at what point does him submitting an affidavit along with the court records and the pleadings, how much more does he need to show that this was false? And here,
You have to show it was knowingly and intentionally made or made with reckless disregard for its truth.
right, and there's cases that in this court, as well as the SJC, that say if you misrepresent someone's prior criminal record, that's reckless disregard for the truth, because as a police officer, you should be able to decipher these.
What's your best case for that?
I apologize. If you could just give me one moment, please, I do have it. Commonwealth v. Dion. And that was this court's decision in 1991. So and based on him saying that this was dismissed based on Duke, we know that he at least looked at the docket. He gleaned that information.
Was the he in that statement?
I'm sorry,
You
what?
said, we know he looked at
The affiant looked had to have looked at the docket to have gleaned some sort of information that the case was dismissed based on Duke and misconduct. He had to get that information from somewhere. I think you can infer that he got it from the
Okay, but we've talked about
docket.
your client doing an affidavit, and you don't mean him, you mean the two police officers.
The two police officers, yeah, discussing whether or not it was a reckless disregard for the
Is
truth.
the docket from the 2009 case actually in the record, or only the margin endorsement?
It was also included in the record. And so that's one of the misstatements. The other ones listed in the brief at 24 and 25 go towards the transcripts that weren't submitted with the wiretap warrant. So there are two transcripts. It was two recorded phone calls with a confidential source of information who had met with Mr. Class on two different occasions. The first time he met with Mr. Class, he was cooperating to get out of the drug debt that he supposedly owed. It was supposed to be $1,600. In the recording, he very clearly says, I'm giving you the $900 I owe you. They gave him $1,600. He gave Mr. Class.
Right, so he steals from the police.
Right, and so.
Right, but that, I think they're going to get up and argue, well, so we knew he was a criminal. That's not a surprise, but the main things that he told us were basically that the guy was a drug dealer, which he was. It was a drug debt, so whether it was $900 or $1,600 isn't material, and he did two controlled buys.
Right, and so, one, we don't know at what point in time he accrued that debt. It could have been a long time ago. But it's the Commonwealth's burden and the affiant's burden at the time to establish that this informant is reliable. If he does not tell the judge that, hey, he stole $700 from us, but we've independently corroborated his information based on X, Y, and Z, which he says we independently corroborated his information, didn't expand further as to how he was cooperated.
So I want to make sure I understand your argument. You're saying they didn't submit the 2 transcripts and that they didn't fairly characterize them?
Correct. Yeah, the transcripts are important for 2 reasons. One, it shows that the informant was not trustworthy, and 2, it shows that there's no, what the informant said that Resto and Class are partners is not borne out in the affidavit, in the transcripts. The transcripts show that there is no connection between the 2 in their drug dealing businesses. So if this was a warrant to get a probable cause to seize, to somebody's house, we're standing in a different position. This is a wiretap. They need to establish organized crime. And so that.
They need to establish organized crime, did you say?
Right, because this is under the wiretap statute, which is a very narrow definition. And so for the affiant to say that these 2 are connected based on information provided by the confidential informant, he needed to tell the warrant issuing judge that there might be issues with his trustworthiness, but he's cured that through his controlled buys, and it's for the warrant issuing judge to decide whether or not that was, his trustworthiness was sufficiently cured. The third bucket of lies really goes to Mr. Class's connection with Mr. Burgos. So this was a wiretap affidavit that there was 3, I believe, or 4 wiretaps prior to this, where the target of the investigation was Burgos and his heroin trafficking scheme. When they applied for the warrant on November 20th, they have never intercepted any call whatsoever between Burgos and Class. That's not what the affidavit said. And the Commonwealth in their brief concedes that the affidavit didn't include details of the conversation. But below, the Commonwealth conceded that there were no conversations at all prior to the warrant.
And where is that in the record?
So that's the the June 2019 transcript. If I could prove, I had a site here. And there was also an agreement submitted to that effect. It was Exhibit 12 in the, there was an agreement between the Commonwealth and the trial attorney that there was no conversation prior to November 20th between Burgos and Class.
Okay.
So the only conversation that occurred that had anything to do with Class was Burgos and his girlfriend they were intercepted discussing boxes of heroin, and his name, Class, the name Class or the word Class was mentioned on that. That's the only
Right, but it was
connection whatsoever.
not insignificant. It was that Class wanted a large quantity of heroin, right?
I agree that it's not insignificant. What I would say to that is that at the time that they applied for the warrant for Mr. Class, the purpose of the investigation had now shifted, and it was to reveal the source of supply of David Class and his cocaine trafficking. Burgos was an organization about heroin trafficking, and it sounds a little ridiculous to say, but those 2 things are very separate. They were 2 different, they weren't, there was never any allegation that Burgos had any involvement with cocaine or the cocaine source of supply. So the purpose of the actual wiretap at that point in time had changed. I would say that the information about Burgos and him muttering Class's name on an earlier wiretap was insufficient to establish that Class was involved, or irrelevant to really whether Class was involved with cocaine trafficking. You had a question?
Well, you have a little bit of time left. I was wondering if you wanted to answer the Commonwealth's argument that the package really has nothing to do with anything.
Yeah, so he was not charged with it. And I will make that clear. He was never charged with the kilo of cocaine that was found in that package. But what it does, this was a conditional plea, and he preserved that right, and he preserved the wiretap because that mattered to him in pleading guilty. And this would have been information that was presented at trial. It was information that was included in a search warrant affidavit on January 14th for another package and other searches. And it was also used as the reason why there was probable cause to conduct a warrantless stop of him. So it was still relevant, and below the trial attorney also requested a taint hearing to determine how, if the court was to determine that this needed to be suppressed, that it was illegal, what would it be suppressed from? How far does it go? Well, it would obviously be suppressed from trial if it was an illegal search, but also whether or not it would be excised from the January 14th warrants.
So, I'm sorry, I want to make sure I understand you. So you're saying that it matters to him that we decide that the package wasn't admissible, because then he might want to withdraw his plea?
It was as part of the consideration of the conditional plea, yes. So it was, the Commonwealth had intended on introducing that at trial, if this was going to come to a trial. It was also used in it wasn't used in subsequent renewals of the wiretaps, but it was used in the search warrants that were conducted on January 14th when he was arrested. I see that I'm out of time.
Can I ask one more
Yes.
record question? You said that the docket of the 2009, or maybe it's 2010, based on the docket number, I can't be sure, case is in the record. I see a docket in the Commonwealth's record appendix towards the end, and if that's the one you're referring to, then on the very last page of the docket, pages 173 and 174, all the charges in the case seem to have been null prossed. Oh, I see. It's charge 4, conspiracy to violate drug law, was vacated and dismissed with prejudice pursuant to the Dukan omnibus order of Justice Gaziano in 2018.
So that is the docket that I am referring to. I apologize. I thought that it was included in ours, but I appreciate the Commonwealth including it in theirs. Is that relevant to, because Burgos and Resto and Class were charged under the same docket. So I don't know if that was in reference to, without having it in front of me, I apologize.
So count 4 just relates to Burgos?
To Resto or Burgos?
I'm sorry.
I do this, it's okay.
Said that who was charged in the same?
It should have been Resto and Mr. Class. And so Resto's was dismissed based on Dukan. Mr. Class's was dismissed much earlier on based on a lack of probable cause. And
Is the docket specifically referring to Class in the record? Because this docket refers only to Resto, as far as I can tell.
but if the docket is for just Resto, I would imagine Mr. Class's wouldn't be on there, possibly. We submitted, though, the order of the court as well as the motion that was filed regarding the dismissal of the case based on probable cause.
All right, well, if you would just make sure that we have the dockets you think we should have.
Absolutely, I will submit that, and I'll also submit the motion for reconsideration so your court has it and does not have to look through the assembly of the record. And I appreciate your time. This case was a lot of facts.
I had one other question, which is the Commonwealth argues that the defendant did not raise the reliability of the K-9 in the motion to suppress. What do you say to that?
So I've had this issue in other cases too. We're not challenging the unreliability of the K-9. What I'm arguing is that the affiant, it was his job to say why this K-9 was reliable. So it's just one factor in the probable cause analysis of the 4 corners of the document. He should have said what his success rate was, whether there were false positives, and if that is what they're relying on to conduct the search and to issue a warrant, then he should have included all of the facts necessary for the warrant issuing judge to determine whether or not the K-9 was reliable. So we're not saying he's unreliable, it was just a factor that should have been considered.
So to establish the K-9's reliability, you have to submit evidence of how often the dog was wrong, as well as how often it was right?
Yes, and that's what Ramos says, is that the Commonwealth v. Ramos, is that it goes towards the weight that the court should give it. So if you are able to establish that this dog is reliable 100% of the time, the judge should be able to give it more weight than a dog that's reliable 70% of the time. Thank you very much.
Thank you. We'll hear from the Commonwealth.
Thank you. May it please the Court, Cynthia Payne on behalf of the Commonwealth. Your Honors, I would first like to bring the Court's attention that the 12b-6 conditional plea, the appellate issues being reserved were the denial of the defendant's omnibus motion to suppress, which was document number 17, in the denial of the defendant's amended motion to suppress, which was document 23. Not the denial of the motion to reconsider. It was these 2 dockets. these two pleadings. I just want to bring that to the court's attention. I'll start with my sister's issue number 3, which essentially that the motion judge, Judge Sweeney, abused her discretion. I believe that's what my sister says. It's a Como's position that Judge Sweeney did not abuse her discretion when she denied the defendant's request for a Franks hearing. I would note that this court gives great deference to the motion judge's discretion, and it's not an abuse of discretion simply because this court might have decided it another way. Here, the defendant had the burden to make substantial showings, 2 substantial showings. First, that there were false statements knowingly, intentionally, or recklessly made, and that those statements were material to the finding of probable cause.
Okay, so as I said to your opposing counsel, first thing I did was put each statement into a chart. You say on the first alleged false statement that this was a threat by Resto, not the defendant. Can you tell me why that matters?
Well, one, it's whether or not it's about the affiant, not the informant. So Frank's hearing isn't designed to impeach the informant's veracity. But regardless of whether it was Resto who threatened it, it's not the defendant. And I would suggest that because this particular instance was not brought before the court, Judge Sweeney was not aware of this, the motion judge cannot be faulted. But again, I would suggest it was attributed to Resto, not to the defendant. This is in regards to the defendant, Your Honor. Did that answer your question?
Okay. All right, and the next one seemed to be the biggest one because you've conceded the defendant's charges were dismissed for lack of probable cause and not evidence tampering, and it was Resto's charges that were due to evidence tampering, right?
That's correct. I would suggest that was not knowingly made by the...
Okay, and can we just break it down because there's so much spaghetti thrown at the wall here. So you agree it was an incorrect statement?
Yes, I do.
Was it material?
Absolutely not. It was a dismissal. It was historical data. It doesn't take away from the fact the defendant was arrested in 2003 for drug charges out of New Jersey. He was also...
Right, but I have to say she did much more clear in the oral argument that, basically the problem with this statement is you have to show organized crime, right, to get the wiretap, right?
Yes.
Okay, and so she's saying this gave them a tie together from years before that was not accurate. And that's why she's saying, do you agree it does link them?
Well, certainly they were both arrested together, Your Honor.
They were arrested, but the charges went away for him because there was no probable cause. That seems very different than evidence tampering.
Your Honor, it's my understanding that counsel for Mr. Class came forward with a motion to reconsider. Judge Page allowed that motion to reconsider. Mr. Resto's attorney didn't come forward. Regardless, I understand that...
My question is, but when you have the dismissal for lack of probable cause, does that sever the link between the two of them? Because you're trying to link them, right?
That's correct.
So when you have the dismissal for 2 very different reasons, does that, does it weaken the link? Does it sever the link?
I would suggest not. It is not material to probable cause, I would suggest. And Judge Sweeney found that was not material to probable cause. This was made clear to her, especially during the hearing on that matter. But Judge Sweeney determined that was not material. The same thing in regards to the fact that defendant and Resto were not overheard in conversations pertaining to the purchase of heroin. It certainly was not disputed that Burgos was overheard talking with the individual who boxed the heroin for him, which happened to be his girlfriend, that the defendant wanted 4 boxes, 3 to 4 boxes, and that Resto wanted boxes as well. Again, this was information that the motion judge heard. Again, she determined that it was not material to the finding of probable cause. I would note in regards to the purpose of,
Well, before we move on, and if it makes it easier, if you want to look at her brief, that there's a list of all of the misstatements or alleged misstatements or alleged omissions in her brief. But one of them is F, which would be on page 24 of her brief, that class was also named as a target in the order. And I couldn't find a response in your brief to that one. I could have missed it for sure, but that's why I'm telling you it'd be much nicer for us if you made a chart where you just had a little table and then you just lined up your responses, because, we're busy and we care, but we're really busy, so we might miss it. But if you put in a little chart, we will absolutely not miss it. Because there'll
Certainly,
be
Your
a
Honor.
box and then a little response.
Your Honor, the defendant's sole basis for alleging he wasn't named as a target is simply that, his affidavit.
Okay, all right.
And I would suggest that's insufficient.
Is there any other response? I just want to make sure we
No,
know
Your
your
Honor.
position, because we're going to go we'll be left to wander on our own if we don't
No,
know
Your
your
Honor.
spot, so we want to know. Okay. Then on the omissions, did the CS lie about the debt that he owed class? Did he steal money from the Commonwealth, basically?
Your Honor, I would suggest the transcript.
I don't want, we can debate the consequences of it, but what I don't like to see is arguments about a factual dispute at the appeals court. The facts should be pretty settled by the time you get here. They're often not, but they should be. So did he lie? He told the police it was $1,600, and then on the conversation, he says it's $900?
It certainly can be interpreted from the transcript that possibly he lied, but again, a Franks hearing, which this issue is about, is not designed to impeach the informant's veracity. It's known that he had a drug debt. I mean, it was very much made known to Justice Kinder, who signed off on the warrant, that this was not an upstanding individual. This was a confidential source who was involved with these people. He was not, I would suggest, Judge Kinder very much knew that he was not a law-abiding source. I would note that the purpose of the November 20th 14 warrant was to both expose cocaine trafficking, develop evidence necessary to prosecute the targets, and to develop the evidence to prosecute the target sources for cocaine, heroin, and other controlled substances.
So heroin was in there, because she says that the conversation between Burgos and the girlfriend was heroin and your focus was on cocaine. But you're saying they were trying to get to the source of heroin too?
Yes, Your Honor, and I would suggest the Commonwealth's appendix, page 18, it's very clear in the affiant's affidavit that what the dual purpose of the November 20th warrant was.
So on the omissions, alleged omission B was that class had no involvement in the problem, it's C. Class was not a partner of Resto and consistently referred to Resto's drug business as just that, Resto's. Sorry if I was tired when I was reading your briefs, but I did not see a response from the Commonwealth on that. I mean, there's the omnibus response of it doesn't matter if you put the false stuff out and you put the omissions in, we still would have gotten the warrant. But is there a particular...
Again, this falls under the fact, this is the defendant saying that he was not in a partnership. This is not, and I would suggest that the transcript of the buys don't necessarily, they can be interpreted all different ways. It's very disjointed. I know my sister refers to the transcript at some point, but it's very disjointed. It's hard to decipher what, in fact, they're referring to. So I would suggest that the fact that the defendant has denied this, again, does not detract from the finding of probable cause. I would suggest, so if the court has no further questions in regards to,
Yeah, you go.
Well, this is a question about the dented circle package, so if you want to stay on this topic, then let's stay.
Okay, so there's a lot going on in this case, so I just want to reduce
Right.
so we can really focus on the legal issues. So it sounds like you're saying that Class is right, that there was not a single wiretapped conversation in which Class is overheard discussing multiple box quantities of heroin from Burgos. It's Burgos and the girlfriend.
it's
Or-
Burgos and the girlfriend, and that's correct. And I do know that in the June 3rd, 2019 hearing, there was a stipulation by the Commonwealth, but this hearing took place in 2017, this hearing with Judge Sweeney. So the fact that there was a stipulation after the fact is, I would suggest, should not be, that was not before Judge Sweeney.
Okay. So what were the dates on that again? What was the stipulation came in when?
June 3rd, 2019, that was in the second hearing with Judge Ritter.
Okay. The defendant argues the police did not even attempt surveillance of Class or his home. Is that correct?
If are we talking about necessity, Your Honor?
Yeah.
It's unknown. I would suggest that the affiants listed quite a few procedures that they had both attempted or just could determine were not feasible. They knew GPS wasn't going to be feasible because other people drove the same car that the defendant drove. Grand jury subpoenas would not be feasible because it could alert the targets as to what was happening. Undercover officers weren't feasible because, as they determined that the defendant was a seasoned trafficker and really had surrounded himself with upper echelon. So I would suggest that there were quite a few alternative means that had been previously used. And
I think we understand, and time
Okay.
is short. I know we let defense counsel run over, so we will, in fairness, and I'm sure I have a few more questions, you will also run over. Why don't you?
Yeah, I just wanted to ask about the seizure of or the search and so forth of the Denton Circle package. You argue that because he wasn't charged with anything based on the contents of that package, and it wasn't connected to or the basis of his arrest on later charges, then he somehow can't move to suppress it. I don't quite know if it's a standing argument or what it is, but it seems to me that unless it's suppressed, it could be offered at trial as some kind of, prior bad act. So why can't the defendant seek to suppress it?
I would suggest in terms of the defendant could have suppressed it. What would it have done? That's a rhetorical question. I apologize.
Yeah, no, I'm not getting at whether it makes a difference, but I'm asking I want to understand your argument about why he can't even seek to suppress it.
Well,
Whether he can suppress it on this record with the finding of no state action is a separate question.
Well, that was certainly the Commonwealth's first argument, that the
Right.
fact that it didn't relate to anything. So I wanted to certainly bring that to the court's
Can it be
attention.
used-
But
if this case were to go to trial, could that evidence be used? Could it be introduced, or at least could the Commonwealth try to introduce it?
well, certainly if the judge had not suppressed it, possibly it would have. The Commonwealth would have used this as a prior bad act.
Right, so
And the defendant can press in this appeal the argument that should have been suppressed. I mean, whether the defense is going to win on that argument is another question, but I just wanted to make sure I understood the Commonwealth's argument about why the defendant couldn't press it.
Again, I think that because it doesn't go anywhere, that was just the Commonwealth's point, that it's not connected to anything. It was a factor in possibly the stop of the defendant back in January, but nothing else. He wasn't charged. The affiants didn't use the basis of that for any other search warrant. So that was just the Commonwealth's point. But then there was an evidentiary hearing on that issue. Judge Ritter determined that this seizure was fine. He credited the affiant, okay.
Okay, but what she argued just a few minutes ago was that it was a significant factor in him agreeing to enter a plea.
I did not read that in the transcript. That's not in the pleadings before the court, that was a significant factor, so maybe, so that's all the Commonwealth can say. That's certainly not in my sister's brief.
Okay. On the package and whether it was state action, you argue that the defendant had the burden of proof to show it was state action to get the package. And you may be correct on the state of the law as it is, but to be quite transparent, I wrote a dissent in Commonwealth versus Mitchell, which is being heard now by the SJC on Monday, saying that sometimes we shouldn't put the burden of proof on the defendant when the defendant has no control over the evidence, which is what this case is, right? Because 4 years later, we have a hearing over what happened between the DEA agent and UPS. And the DEA agent basically says, I have no memory. He remembers a couple of little details, but not much. And the UPS people were just like, 4 years of packages, I got nothing. And so why should it be the defendant's burden of proof? Because the Commonwealth controlled all of the evidence. And in fact, the defendant fought like heck, and it took him 4 years to get his hearing. He had to go up to the SJC to get it.
In regards to the DEA agent, Your Honor, I would respectfully
Well, you might not have
disagree.
had total control of him. I grant you that, but you had more control than the defendant did.
Yes, but I would also say in regards to his testimony, he might have been vague on some of the details. He was very clear that he did not order, request, ask for the UPS to take that package. I think he was very clear in that regard, and Judge Ritter credited, it was DEA agent Smith, I believe, he credited that individual, saying that he had not ordered, requested, asked the UPS.
So the defendant says, yeah, but he caused it. I mean, once the police say, oh, we're interested in this package and we think it has drugs in it, and oh, it's just too bad we can't get it. And then UPS very helpfully says, oh, here it is.
Well, Your Honor, I would say in the Claiborne case, actually, I'm sorry, Your Honor. Actually, I have a case in which, if I may have a moment, Your Honor. Oh, I'm sorry. Brzezinski, an individual's actions are not imputed to the state if law enforcement did not offer or ask anything to prompt assistance. And that is what the motion judge found here, that there was nothing. The fact that the UPS might have, jumped to do what they thought that the DEA might want, that's.
I'm not saying this happened here, but if hypothetically the law enforcement officer said, gee, it sure would help us clean up these streets if we had that package, it's a darn shame we don't, oh well, and walked away, and then guess what happens? UPS gives them the package. Would that be instigating it?
That would be instigating, and I would suggest that Judge Ritter did not find that to happen. He found that.
Oh, I know what the findings are. So one of the things that's interesting about this case was that UPS had delivered the package, right?
Yes.
And so just to push this point a little bit, I mean, if someone had stolen, let's say it was delivered to Veronica's porch, and someone, Denny came along and he took it, who's the victim there if the Commonwealth brings a lawsuit? Because it's not UPS, right? It's Veronica.
That's correct. This was a very weird situation, I would suggest, because right when the DEA agent had approached the UPS, he said, oh, I just got this email saying.
That was weird. I could never find any indication of who sent the email saying that the package had not been delivered or had been misdelivered.
Right, so that he said there's an email. So I think it was a very strange circumstance in this, with regard to the delivery, and then they knew it was an overnight package, so for whatever reason, the UPS driver retrieved it.
did it serve UPS's purposes, any purpose of UPS to retrieve that package?
Your Honor, there isn't anything in the record to...
Okay. All right. Thank you. Again, well-argued case, which is great because we have some students here today, so.
Thank you, Your Honor. Thank you.
All right. Our third case this morning is 2023 P904, Commonwealth versus Stacy.
Good morning. May it please the court. Andrew Carassi on behalf of Roger Stacy. Mr. Stacy is entitled to a new trial due to the erroneous and prejudicial exclusion of the sole defense witness aside from the defendant himself, a decision that was made without considering the required Chappie, otherwise known as Durning factors. I would suggest to the court that the failure to make explicit findings on those factors was itself error, but even considering those factors weighs heavily against exclusion here, particularly since exclusion of a defense witness due to late disclosure is reserved for hardcore transgressions where there's been a showing of bad faith by defense counsel and where no alternative...
What published decision says that a showing of bad faith is required to exclude a witness?
So I
know
believe-
that in the Pava case, the court said, among other factors that it considered in, I think, reversing a ruling of exclusion was that, well, there was no bad faith here. But the court doesn't say in Pava that bad faith must be shown.
No, but what the court does say is that this sanction is an extreme sanction and should be reserved for hardcore transgressions where there is a showing of bad faith.
What I'm getting at in particular is a showing of bad faith required?
I would suggest that that's a reasonable inference from what Pava stands for. I don't think that Pava used that exact language, but I think that the inferences drawn from Pava and the other case laws that have addressed this issue is that there needs to be bad faith. If there's not bad faith, the court, I don't know of any case where the court has not reversed.
Well, if bad faith was the sine qua non of exclusion, then why do we need a 5-factor test?
I suppose that's a fair point, and perhaps it's not affirmatively required when the other factors strongly counsel in favor of exclusion. I could imagine a scenario where it is overwhelmingly prejudicial to the Commonwealth, some type of extraordinarily complex and lengthy testimony, a very late disclosure, the Commonwealth is surprised. I suppose there could be circumstances where there is no bad faith, but the prejudice to the Commonwealth and the surprise to the Commonwealth, and indeed the availability of alternative sanctions. So, for example, you could have a situation where...
So you're hypothesizing that bad faith is not always required?
I suppose it's not always required. I'm not going to die on that hill, Judge. I think that it's a situation where it is...
Bad faith here.
There's definitely no bad faith here, and I think it's one of the most important factors that the court considers. And here, in addition, not only is there no bad faith, but I would suggest that all of the other factors counseled against exclusion, particularly we look at surprise. So this was a situation where, and of course I should say that this was two different errors here. Of course, there was the pretrial decision and then there was the motion for new trial, and I don't really want to conflate that, so I'll address the pretrial decision first. On the record, when the pretrial decision was made, what was put on the record was that the witness was disclosed the night before. Now, putting aside what came out in the motion for new trial.
We understand the timing issue, that it was actually disclosed the preceding morning.
Right.
But what do you think that any of the 5 factors weigh in favor of exclusion?
I do not.
What about the materiality of the testimony to the outcome of the case? The Commonwealth seems to argue that this testimony would have been cumulative on a fairly weak point, because what the offer of proof is that the defendant's then fiancée, at the time of trial wife, says she testified that every day when he comes home he stinks of chemicals, he stinks of smells. She never says, it's never suggested that she will testify, he has a smell about him that could easily be confused with alcohol, or that I think is alcohol. Because I ask him all the time, have you been drinking? She never mentions alcohol in the offer of proof.
And I would suggest to the court that it is implied by the offer of proof. I mean, this is a proffer.
When you're making an offer of proof, can you leave things to implication, or don't you need to say exactly what it is? Because it makes a real difference.
I think that it's certainly the better practice to be more explicit, but I would suggest to the court that what was put on the record was explicit enough to show that
But
she
even
was-
after trial, if I'm remembering correctly, the affidavit of counsel still doesn't mention alcohol, does it? Or certainly doesn't suggest she's going to draw a comparison.
Sure. What it does...
So, you know, counsel's had two chances here, not you, but trial counsel has had two chances to say what she would have testified, and in neither instance does he suggest that she's going to directly say the smell that he comes home with on his clothes is very similar to, or I confuse it with alcohol. So in that case, where's the materiality? Where's the prejudice?
So
from
just
not
on
letting her
the
testify?
first point, so what counsel does say is that she, as the court pointed out, is that she would testify to this smell of various chemicals that would cling to him, and he'd have to take off of his clothes and all of that. But what counsel also says is that the trooper is going to opine that this was the odor of alcohol. But he is going to argue, in light of Ms. Pino's testimony, that the trooper confused this with alcohol. So the only way that he can argue to the jury what he's saying is if he introduces evidence.
Why couldn't counsel have asked the defendant on direct when the defendant testified, so what's this smell like that you come home with? And the defendant, if he thought so, could have said, it smells like alcohol to me.
He perhaps could have asked that question. I would suggest to the court that there is some distinction between what a third party smells on somebody versus what somebody smells on themselves. For example, this is a gentleman who is working all day. He's among these odors. This is a situation where it's sort of like when you walk into somebody else's house, you may smell an odor, but when they walk into their house, they don't smell an odor. There's a distinction between a third party, how a third party interprets the smells coming off of him versus somebody who is, in some ways, I'm not going to say immune to the smell, but he's in the smells all day. The chemicals are radiating all day. I don't know that he was really in the best position to offer that opinion, but perhaps he could have. But a corroborative witness who's telling it from the perspective of a third party.
He's aware of the smells. He testifies. He's asked, are there smells in that factory where you're working? Yeah. On that day at the Amazon factory, were there smells? Yes. What are those smells caused by? Fumes from the Bobcat, the ram hoe, the jackhammers. There's a diesel backhoe, ram hoe. And do those fumes stick with you after you leave? Yes. So the defendant's clearly aware of them. If he wasn't aware of them, then he wouldn't know whether they stick with him when he leaves. So why couldn't he have testified they smell like alcohol?
Sure. I think that he knows that he smells like it afterwards because his fiancée, Ms. Pino, the excluded witness, is making him remove his clothes and take a shower before he comes into his house. Whether he smells it on himself is another story. But what I would say to the court as well is that part of the materiality here is in light of the corroborative nature and how she would bolster Mr. Stacy's credibility. So I do believe that the proffer encompasses the notion that she would have offered an opinion about what he smells like in the comparison of that to alcohol. But even if the court disagrees, what she would have been doing is she would have been significantly corroborating the story of a defendant who clearly is coming from a position of bias as far as the jury is going to look at it. I would suggest
But his wife testifying at trial isn't biased.
Of course, the Commonwealth is free to argue her bias, and there's a relation there, and I appreciate that they have that argument, but she's not the defendant himself. I think that the defendant himself comes from a position where people are going to look at the defendant as being more biased in offering self-serving statements as opposed to some third-party witness. Surely the Commonwealth could argue that she was biased because of the relationship, but it's entirely different than just the defendant himself. And I would note as well...
But when we're evaluating prejudice on appeal, and upholding a ruling by the trial judge denying a motion for new trial, who is familiar with the evidence, can we consider that had the wife testified, her bias would have been certainly exploited by the Commonwealth, or her potential bias, and that with solid foundation, and that is a consideration in whether her testimony was material?
I think that the court can certainly weigh that into whether or not the defendant was prejudiced by the error, of course, but The question is here, and I think part of materiality, of course, goes to the strength of the case, right? And so you have to analyze it not only in terms of what the Commonwealth's argument would have been with respect to bias, but would it have made a difference to the jury? And the one thing I want to point out is that on the point of corroborative nature, so the Dranka case is one where the proposed testimony was exclusively corroborative by my view of it. So this was, the Dranka case was a situation where the defendant testified effectively to
Yes,
having had a vasectomy, and the court's
Right,
familiar.
but in the Dranka case, the testimony was coming from the physician who had performed the vasectomy, who had no obvious bias.
Of course.
And it was directly on point to a critical piece of evidence. There was a rape kit taken, sperm was found in the rape kit, and the physician would have testified would have corroborated the defendant's testimony that he had a vasectomy, had been tested, and was incapable of producing sperm. That seems to me a lot more on point from a witness with no obvious bias than the wife here testifying he's, according to the offer, he would come home and smell like chemicals.
Sure, and again, I think that the court can consider the notion of her bias, but what I don't think the court can do is say that, well, the Commonwealth would have articulated some level of bias and therefore it added nothing to the case. The question is, would it have made a difference?
But you mentioned Dranka. Would you agree that the testimony in Dranka was more directly harmful to the Commonwealth's case than the testimony of the wife would have been here?
I would
Physician saying he can't produce sperm, therefore, how could he be the source of the sperm found in the victim?
I think it's similar in the sense that the defendant had already testified to all of that in Dranka. And sure, it's a physician versus the defendant's wife, but he'd already testified to it, and they wanted to call in an expert to corroborate that point. Whereas here, not only, again, as I've said, not only is she corroborating what the defendant is saying, but she is indeed adding additional material points here. And we can quibber about the odor of alcohol, but she's also able to obviously offer an opinion about the way that he sounded on the phone. Did he sound like he was drunk?
I never saw that mentioned in any of the offers of proof, either before trial or in the new trial motion or even in your opening brief.
And I appreciate
I applaud you for thinking of more things that she could have tried to testify about, but it would have been helpful if trial counsel had offered those before the judge ruled that she was excluded.
I think it certainly would have been more helpful. But again, I would note that proffer as a general summary, I think it's not an exclusive and binding list about what she's going to testify to, and he's trying to get her...
No, but you've got to lead with your strongest points.
So, but part of the challenge for us here is that I think the defendant, in an effort to get the wife's testimony admitted, said expressly that it was not, her testimony was not particularly significant.
And I think what trial counsel, and I'm not in the head of trial counsel, but what I think the trial counsel was trying to say there was he was making an argument on prejudice to the Commonwealth. I don't think he would have filed a motion for a new trial if he thought that her testimony was meaningless. What he was saying to the court was she's not that complex of a witness. She's not a percipient witness. She's here, and she's not that significant is what I think the word that he used, in the sense that her testimony is not prejudicing the Commonwealth from the late disclosure. I think that is what trial counsel was intending to say. I don't think the trial counsel, in an effort of trying to get her testimony admitted, would have basically said she's not offering anything, which is what that sounds like. I appreciate, but I think in context what he's saying is this is not a complicated witness. She doesn't have lengthy testimony. She doesn't have complicated testimony. This is not something that the Commonwealth has to prepare for.
So
I think
that
that's
brings us to the issue of less severe sanctions.
Yes.
You know, given that argument, you know, that this is not something difficult for the Commonwealth to have to deal with. What were less severe sanctions at this point than excluding the witness altogether?
I think every sanction that the court could envision was available at this point, particularly
Well, nothing was suggested, right? No alternatives were suggested.
No alternatives were suggested, but the court is required under Chappie-Durning to consider alternative sanctions. So the onus is on the court. The onus isn't on the defense for not requesting them. But to answer your question directly in terms of what was available, I'll give a lengthy list. Jeopardy hadn't attached. Motions in limine hadn't began. Jury impanelment hadn't started. So the trial hadn't started. So in the first instance, a continuance.
After, this is the fourth jury trial date, right?
It was, and some of that was due to the pandemic and continuances, and I appreciate that the case was old, but nonetheless, it was available to the court to grant a continuance. What also was available, the court could have ordered a voir dire, the court could have allowed the Commonwealth to interview the witness, the court could have stepped it back for a couple of hours and let the Commonwealth prepare. The court could have done anything other than excluding the witness. And the court didn't consider any of those factors. The court just very, very quickly made a ruling that she was excluded without considering not only any of these factors, but in particular, any of the other sanctions.
Since your time is running low, can I ask about the evidentiary hearing issue?
Yes.
What factual issue was raised by the motion for new trial that required an evidentiary hearing to resolve?
So two things. So one, I do think that the motion for new trial in and of itself, the factual showing was indisputed such that the court could have and should have ordered ordered a new trial without the need for an evidentiary hearing. But one of the things that the court could have done at an evidentiary hearing was had the proposed witness testify. Had the proposed witness testify and do effectively the voir dire that he...
But if we take everything that was said in the affidavit as what she would have testified, can't we then review whether the motion for new trial was within the judge's discretion to deny? Or do we have to assume that if there had been an evidentiary hearing, she would have testified about a whole lot of other things that would have made the case stronger?
I think that the court, at this stage, in determining whether there's a significant issue, the court has to know exactly what she's going to testify to and not just a general summary of the proffer.
Right, and how does the court know that?
By ordering an evidentiary hearing, because there
How
was a
about
significant issue that was raised by the notion that we know that the Commonwealth wasn't particularly surprised because they knew before the morning before. We know that there was no bad faith. We know that there was no prejudice. So the court, again, could have granted the motion, but I don't think because it raised a significant issue, the court couldn't have denied the motion without an evidentiary hearing, because if anything, the witness could have come in and testified to precisely what she would have testified to, and then this court would have had the benefit of a full record.
Well, it's not just the significance of the issue, but it's the adequacy of the defendant's showing on the issue that goes into the calculus of whether there has to be an evidentiary hearing, I think. And where the defendant has had every chance to put together an affidavit showing how the wife's testimony would have been material, and this is what he comes up with.
I understand, but as I mentioned at the beginning, I do believe that this proffer encompassed a fair reading of this proffer that was submitted in the motion for new trial encompasses the notion that she is going to offer her opinion of what he smelled like. And she was going to offer an opinion that would have supported the defense's argument that the trooper could have confused this smell for the odor of alcohol. That's a significant issue. So on its face, this proffer raises a significant issue, particularly in light of the notion that every single one of the other Chappie factors counseled against exclusion. Looks like I'm out of time. If the court has any further questions, I'm happy to address them.
Thank you very much. We'll hear from the Commonwealth.
Good morning. May it please the Commonwealth. May it please the court. Catherine Jansen for the Commonwealth. Sorry about that. I'll first just start with the motion for new trial issue, just briefly. Here, there was no substantial showing, not only apart from the fact that I would suggest no new facts were proffered in the affidavit submitted by defense attorney, but there was also no affidavit submitted from the defendant's now wife that would have elaborated on what she could have or would have testified to. So I think on that basis, there was no abuse of discretion for the judge to deny the motion for new trial without ordering an evidentiary hearing. As far as the decision to exclude the wife's testimony, I think this case honestly really rises and falls on the prejudice. Conceitedly, the judge did not make explicit finding.
Can we go back to the law for a minute? You cite in your brief Commonwealth versus Reynolds for the proposition that the judge must make explicit his findings regarding the 5 factors.
Correct, Your Honor. And
that's the law, right?
Correct.
And did the judge do that here?
No, Your Honor, which is why I was going to say I think this case conceitedly rises and falls on the any prejudice that attaches to the excluding the wife's testimony.
So not prejudice as one of the 5 factors in the Durning-Chappie test, but prejudice in
Or
the sense
prejudicial
of
error.
whether this is prejudicial error.
Correct, and I think, they do kind of overlap a little. I think the determining factor about materiality kind of coincides with the prejudice to the defendant, or lack of prejudice, I would argue, because I would suggest that this testimony was not super material to his case.
Do you have a case where we or the SJC have said, okay, the judge did not make the explicit findings, but there was no prejudice, and we affirm?
I believe I have a case, if I could have a moment, Your Honor. It is unpublished, which is why I didn't put it in my brief from
Right,
this
but it's
court.
actually important for the parties to tell us if we need to publish in a particular area.
I could just find it. This is Commonwealth v. Felici. It's 99 Mass App Court, 1101, 2020. I can give the docket number if that's helpful.
Okay.
And here, in that case, the judge did not explicitly put on the record the findings that the Durning factors had been met to exclude the evidence, but because there was, the proffer was speculative and it lacked materiality to the case, there was no error. If that answers your question, Your Honor?
So focusing then on prejudice, did the Commonwealth attack the defendant's credibility in closing? I mean, wasn't that really a large portion of the Commonwealth's case was attacking his credibility?
I mean, yes, part of it. However, when you're talking about these other cases where it's been found an error, attacking the credibility of the defendant, it's not just enough to corroborate the defendant. In all these other cases, they were either one, percipient witnesses, or two, they added another fact that bolstered, a new fact that was not at issue in trial that bolstered the defendant's credibility. And here, her testimony, that even if you want to take that she could have testified that he called her and said he ran out of gas and was looking for a mile marker, that fails to address how the Commonwealth attacked his credibility, in that the mile marker was right next to your car and you kept walking down 95. So that wouldn't have, it's not as if the Commonwealth exploited this absence in that regards. His credibility on that issue wouldn't have been bolstered in any differently in the way the Commonwealth had chosen to attack it in closing.
So there's an argument between you and the defendant about whether certain testimony that was proffered would have been inadmissible. And they're arguing that she could have testified as to how the defendant sounded to her, or that he was looking for a mile marker, not for the truth of the matter, but that his story was consistent. So what do you say to that argument?
I would suggest that her testimony was, again, can you repeat the question? I'm sorry, I was kind of thinking.
They're saying that some of her, you were arguing that some of what she would have testified to was inadmissible hearsay, and they say, but no. And they argue she could have testified, for example, that he sounded normal, or he wasn't thick-tongued, his words weren't slurred, or that...
That wasn't part of the proffer, Your Honor, that he wasn't that there was never part of the proffer before she was excluded or during the motion for trial about how he sounded on the phone, that he was not slurring or not thick-tongued, to the extent that she could have testified that he called her and said he ran out of gas. I guess reflectively, I would concede it might have been admissible for state of mind evidence as an exception to hearsay. I had argued below that, or in my brief, that it was hearsay, but even then, as I just said, I don't think it matters that even if that part is corroborated, that he did run out of gas, what he called and said he ran out of gas, says nothing about how he sounded on the phone or the fact that the mile marker was right next to his car and he chose to keep walking down a very busy highway, and how the Commonwealth impeached that evidence. And
So, in a case that depended on credibility, because we don't have an accident, the car was parked normally, to the extent you can park normally in a breakdown lane. We don't have alcohol containers in the car. So could the wife's testimony in that circumstance be considered cumulative?
I do think it's cumulative of this is not a case where the defendant wasn't able to get out his defense. He was, through his own testimony. There's no suggestion that he had to testify because his wife's testimony was excluded, and I think that's important. But also, just because it merely corroborates that he ran out of gas, I don't think that's enough, as Justice Sachs pointed out, that she could not corroborate, one, how he smelled that night, which I think is important. I think if she had been a percipient witness and had smelled him, we might be on different footing, but we're not. But also, too importantly, there's no suggestion anywhere in the record that she would have testified that his chemical smells after working was akin or could be confused to alcohol.
Right, but is the defendant correct that at the end of the trial, the state of the evidence was that the defendant smelled like a combination of diesel and other chemical smells?
Correct, and there was no evidence that that could be confused with alcohol.
Right, but
Where
there
was the
was,
testimony about other chemicals? I didn't find that. I saw it in the proffer on page 3 of the transcript, or wherever it was, but there was never, I don't think the word chemicals was.
I think it was fumes, or it was fumes from work, maybe chemicals, fumes, diesel. I think they were kind of used interchangeably throughout the proceedings below. And testimony that he smelled like the fumes from the backhoe or diesel fuel, I would suggest there's nothing to show that in the record that that would be confused with the smell of alcohol.
right, but what was the basis to argue that they do smell, that diesel and maybe other chemicals, or maybe just diesel, does smell different from alcohol?
I would suggest, are we talking about the prosecutor's closing argument now?
Mm-hmm.
Okay, I'm sorry. I would suggest that that's based on common sense and life experience. Just how somebody can offer a lay opinion that somebody's sober or not, because that's based on life experience. I think so too, the jury can take their life experience about having put gas in their car or been around people who are drunk and smell of alcohol. I think those are within the realm.
I'm a big fan of life experience and common sense, actually, but I don't know that I could tell you what diesel smells like. I mean, most cars, there are some cars that are diesel, but most cars aren't. Like, where would the average person, I'm just trying to figure out how the average person would know what diesel smells like.
I think it's a fair inference that diesel fuel and gasoline, they smell similar. To be fair, it's not in the record, but I think that's fairly touching on common sense, that fuel is not, diesel or regular is not going to smell like alcohol.
Yeah, I don't know. I mean, just coincidentally, we had a young person staining something at our house yesterday, and they used the mineral spirits to clean up in a little tiny bathroom we have, and then they didn't know, because they were young, and lack of common sense, that after you wash this off, you really have to use, with the mineral spirits, you also then use soap, and then you dry your hands on the towels. But they didn't know that, so they just used the mineral spirits and then dried their hands on the towel. And then, 2 hours later, I go in the bathroom, and I'm like almost knocked down by the smell, because it's this towel in this little tiny bathroom. But that's what I'm saying. Like, how do you?
Well, I think mineral oil would be different than fuel and gasoline. I think people probably are not using.
People use mineral oil all the time, or mineral spirits, because they paint at home. But if you don't have a diesel car, when would you encounter? I'm asking in all seriousness, because as I say, I'm a huge fan of common sense and life experience. But how would you smell diesel? How would the average person smell diesel?
Just having been at gas stations, I think when people.
That's gas. I mean, if you're not pumping diesel into your vehicle, what does it smell like?
Well, Your Honor, this was the Commonwealth's position, that this is based on common sense and life experience from fuel being different, and we also suggest mineral oils and spirits being different. People know it's chemical smell as opposed to smell of alcohol. Smell of alcohol, I think, is distinctive.
Don't we add ethanol to a lot of fuel? Isn't that an alcohol?
And I would suggest the smell of alcohol is distinctive and the smell of fuel is distinctive, and it's common sense that they don't smell the same.
What did the defendant argue about this in his closing argument?
He argued that the two could be confused. He specifically stated on transcript page 152, the defendant would have, sorry, that was our argument. His argument on page 143, 144, use your common sense, the smell of alcohol and smell of fumes. He smelled something as a worker based upon that. The trooper had him do field sobriety tests. Defendant went to work that morning, he works in heavy construction, he doesn't drive machinery, but he's around them, he smells of work, dust, and things of that. You heard his testimony. So he directly brought it up in his closing, where there was also, I would suggest, no basis in the evidence for him to argue that the two smell alike. So the Commonwealth was entitled to rebut that as well.
Just to go back on the factors, do you agree there was no evidence of bad faith on the part of the defense counsel?
Yes, I would suggest there was no I would say there was no suggestion by the Commonwealth below or now that there was bad faith. The court could have determined there was if he knew who this witness was from the very beginning and didn't put the name on the pretrial conference report, but the judge didn't make an explicit finding to that, and the Commonwealth didn't make a suggestion about bad faith.
So you agree on bad faith. Any of the other factors weigh in the Commonwealth's favor besides, in your argument, the materiality of the testimony, the fifth factor?
I would suggest unfair surprise to the Commonwealth to the extent that, yes, she got this the day before, but in a busy district court, you're not going to have the time to really sit down and look at this and think about what she's going to say or know what she's going to say. And then in the morning of, she's trying to do motions eliminate and panel a jury and get the trial on the road. So to the extent that she has time to really know or research if she has any impeachment value opposed to the obvious of being the wife, or think about or know or interview her about what she's going to say to prepare for cross-examination in those time frames, I think would be unfair to the Commonwealth. Conceitedly, it's not expert testimony or super complex testimony, but...
So a 10-minute recess while the ADA interviews the wife would have been sufficient as an alternative sanction?
I think that wouldn't have been enough. I think, like I said, on the morning of...
Would or would not?
Would not have been enough. I think it ignores the realities of a busy district court and everything that's going on when you're trying to get a trial on the road, to require a prosecutor to be in the middle of motions eliminate and paneling a jury and then stop everything and in 10 minutes think about what she needs to ask her and interview her.
Well, did she have any right to interview her if the wife had said, no, I'm not answering your questions?
Correct, but I'm just saying if that's absolutely true, Your Honor, the wife could have said, no, I'm not going to agree to talk to you. However, suggesting that the prosecutor, should the wife had agreed to be interviewed by her, to be able to think about what you need to switch gears like that is not really fair, is my point being.
Well, so first of all, it was not correct to tell the judge the witness was disclosed last night, right? It was the day before, but
it was the day before. I think that was a matter of semantics, and I don't think the prosecutor was trying to make it seem worse than it was. I mean, again, you're in a busy district court, you check your email in lunch hour.
So had the defense attorney timely disclosed the witness, what investigation would the Commonwealth have done other than checking the BOP, the criminal record?
She could have tried to check the criminal record. She could have tried to have interviewed her. She could have looked at her social media or anything else to find anything else that would be of impeachment value, perhaps, or her, you know, what she did for work or whatever it might be. There could have been a few different things she could have done. I'm happy to answer any other questions the court may have. I see my time is out.
I think we're good. Thank you very much.
Thank you.
The case is submitted.
I'm fine.
Are you okay pressing through? Okay, then we only have 4 cases on today, so we're gonna go ahead and have the fourth case, and that is 2023 P 1015 Scudieri versus Schumann.
Good morning, Your Honors.
Morning.
My name is Mark Ree, and I have the privilege of representing, may it please the court, the appellants in the case, Maria Pia Schumann and Misha Hader, now also known as Misha Schumann. Would Your Honors care for a brief recitation of the relevant and material procedural facts?
We read the briefs quite carefully, and we're familiar with the procedure. If there's some particular thing you want to call our attention to. I know I had a procedural question, which was, when was the first notice of deposition for either of your clients versus the warrants were issued in April 29 of 2019?
I don't have that chronology immediately in front of me. I do know that there were notices of deposition originally issued while a motion to dismiss was pending. And then the procedure flowed from there with the warrants were, excuse me, it is referenced in the brief that the warrants were apparently issued while the motion to dismiss was pending. I do recall that. That is the chronological time frame. And
when exactly did the defendants become aware of the warrants?
I actually do not know the answer to that question, Your Honor.
So the record doesn't show it?
Does not show how they became aware as far as I'm concerned, but I do know they found out.
Wouldn't that be pretty important to for example, their motion to set aside the default or their various efforts to try to delay the deposition in the summer and fall of, was it 2019?
Well, correct, but they certainly, as soon as they found out about them, they did attempt to take action to get rid of them.
That's the question.
Right.
As soon as, or at a kind of a leisurely pace and...
No, I don't believe it was at a leisurely pace. When they were notified of the warrants, things started moving very quickly because opposing counsel seized on their existence. And again, I think it's extremely important that common sense is not checked at the door as to the procedural history.
But how do we know that things move very quickly unless we know when the starting point was, which is when they learned exactly?
Well, because the warrants came out while the motion to dismiss was pending. Immediately during that, opposing counsel seized upon that and started pressing for the depositions even harder. When it was apparent that the conundrum in the Hobson's choice that the Schumanns were faced with, being arrested upon re-entry to the country and therefore being impossible to comply because they would be incarcerated, or not showing up and being wrongfully incarcerated based on false criminal process, which is undisputed in the record. That is the
I'm not sure about that. I looked at the Hay affidavit. He says that the charges of larceny were based on a mistake of his in not recalling that he had given them authority to withdraw this money from his account. And he's quite cagey, I would say.
Which page of his affidavit?
I'm looking for the Hay affidavit.
Around 804.
I can give you the record if...
808.
804 to 809.
So at 808, he says, I also provided the Cambridge Police with the wrong address for the Schumanns, ensuring that they would not get notice of any hearings on the matter, thereby assuring their defaults. Does he say he intentionally gave them the wrong address?
I've read that as English as you have, Your Honor. If that is the case, then that is even another gross abuse of process.
I'm sorry, you said you read it as I have?
Meaning that you just quoted his affidavit, if I heard you correctly, saying that he had intentionally given the wrong address.
I did not quote him as saying he intentionally gave them the wrong address.
Well, he gave them the wrong address.
The quote, yes, he gave them, which resulted in them not getting notice. Was that his design?
Well,
any evidence of that?
If you read the affidavit in that manner, yes, of course, it could be asked the question, did Mr. Hay make a mistake in presenting a criminal complaint to the authorities? Well, leaving that question completely aside, I focus on, I believe, what it is, paragraph 3 of the Hay affidavit, which is really the essential language. Incredulously, he states that his attorney, who also represents Mr. Scuteri, the appellant in this case, Mr. Cooper, who is not here today, encouraged the filing of a criminal complaint specifically to gain advantage in a civil case. And I must emphasize, given the shortness of time, that it is unethical to use threats of criminal prosecution to gain advantage.
You said this is paragraph 3?
I'm sorry?
You said paragraph 3?
I believe it is paragraph 3 of the affidavit, the word that Mr. Cooper encouraged his clients to file criminal charges specifically for the purpose of gaining an advantage in a civil case. None of this testimony was rebutted when presented on what I would say was the salient procedure below, because of course we have a motion to remove a default and then the motion to remove the default judgment. The Hay affidavit didn't exist earlier, and the judge's conclusion that, Justice Green's conclusion in the 10-13-21 decision on the Rule 55C motion, that these documents, meaning the documents that ultimately led Mr. Hay to recant his, at best, mistaken criminal report, that those documents were equally available, I believe was the language used in the decision by Justice Green, to the appellants, such that they could have raised it earlier. That is not in the record. It's not supported. The reply brief addresses that. That is the miscarriage of justice here. The moment that this was walked in, saying you have an affidavit saying that there is a plan to abuse process, aka use criminal process for an ulterior purpose to gain advantage in a civil case.
I'm going to take you back then to the Hay affidavit, because I really wondered if he got counsel before he filed this affidavit, I have to say. But what paragraph are you looking at? Because I'm not seeing it in 3, which is on paragraph 804.
Permission to access my record?
Yes, of course.
Thank you.
I mean, he definitely says he encouraged me to join forces with Scuteri against the Schumans. We had, just the parties understand, we had some technical problems with this appendix. Normally, we can search easily, but there were some issues.
I'm sorry, I may have miscited the paragraph. Just a moment. Paragraph 9.
Thank you.
At a meeting with Cooper, his office on May 15th, he asked me to write a letter to Secretary encouraging him to come forward and take legal action against.
Yeah, but that's not about taking criminal or pressing criminal charges.
Excuse me, Cooper sent a letter to Scuteri encouraging him to come forward and file a suit against the Schumans. So they're all working together. All these clients and the lawyer are communicating.
But where's the using criminal process?
Excuse me. There is no question in here that he stated.
Oh, is it 12?
Yes. They're saying there is no way they are going to show up based on the criminal process. And with Brooks' permission, he says,
Which paragraph are you in?
12.
12, okay.
He says, and then this is what Cooper said to him. Cooper stated that his strategy in Scuteri versus Schuman and Hader was to exploit the Schumans' inability to be easily deposed in order to secure a default judgment against him. Now, I'm sure Mr. Cooper might dispute that, but it wasn't raised below. And this was evidence clearly that there was something amiss here. None of these were materially disputed, the
Right,
attorney-client
well, I hear what you're
relationships.
saying, but did your clients, first of all, they were first noticed for deposition in September of 2018, and the warrants didn't issue until April 29. So your clients were resisting being deposed for a good 6 months, and maybe that was a good strategy, but then it ended up biting them.
I'm not sure that's a correct characterization. There was a delay in the depositions before this criminal issue became out because they were asking for a stay of discovery pending a motion to dismiss, which is good practice. Because of course, if a case is not valid on the merits until the court rules on it, why should we go through the expense of discovery? That's common sense.
Did your clients ever respond to document requests?
Yes, they did produce documents. They offered to appear by deposition by Zoom. What's interesting...
Well, I don't think anyone knew what Zoom was back then.
I'm sorry, Your Honor?
I don't think anyone knew what Zoom was back then. They offered some kind of telecommunications hookup, which the plaintiff opposed, I believe, because the plaintiff took the position that demeanor was very important here.
Well, ultimately, they offered to try to do this by alternative means, but when we go to the factors, and I'm referring to cases like Keene and the 5 factors, which are non-exhaustive, of course, to consider.
That Keene, by the way, was I won't say reversed, but the SJC took that on further appellate review and reached different conclusions.
I would agree.
Than our court did.
Of course, Your Honor. I would say, though, that the factors to be considered, though, generally as a matter of law, are not disputed in this case. We don't have a serious legal dispute. Both parties cite that. Both parties cite Greenleaf, et cetera. But the 5 factors, the degree of culpability, isn't that an easy trap? Of course it's easy to say that they decided and made a choice not to show up at their deposition, so therefore they are culpable ipso facto. No.
Well, I think the question is more, did they diligently try to deal with the arrest warrant issue once they learned about it?
I think they did.
Assuming they learned about it sometime in August of 2019, they apparently attempted to get multiple counsel, including spending considerable time and money trying to get a particular highly experienced criminal defense attorney they wanted, merely to come into district court to get some warrants recalled. Is that could Judge Green conclude that that was not a diligent, reasonable effort to deal with that issue?
Well, I'm not sure that was precisely the basis that in theory could be concluded if it was based on all the facts and circumstances, which it isn't.
Well, there was an effort to engage a particular defense attorney, and problems with transferring the funds from France and getting approval from some trustees that delayed this for weeks. And at the next to last hearing, before the default judgment was ordered, the judge says, okay, now, defense counsel, you're telling me that you can get these depositions done by, I think, November 30th, and that your clients will be there. Can I rely on that? And counsel says, yes, you can rely on that. And then it doesn't happen. So isn't that, I mean, it was pretty clear where the judge was coming from. She was fed up, and with seemingly good reason, and she said, tell me, can you do this? And isn't she entitled to rely on what defense counsel said at that time?
If this didn't involve any of the issues related to an abusive process meant to gain an advantage in a civil case, then I would agree wholeheartedly. As a former clerk to the Superior Court, and with 25 years of practice, I've done many of these motions, as I'm sure you've seen many of them yourselves. But this is not the case of the defendant ignoring process, trying not to be a part of the action, trying not to get arrested. This is a due process issue. We have a transgender person who is in reasonable fear of their lives if they were put incarcerated, and let me explain on the issue that Justice Sachs speaks to, because it's a very good question. I struggled with it myself. I have 3 seconds. 2 problems with counsel. The first, Mr. Fuller, advice of counsel, they thought he was retained, he ghosts them. The second one, Attorney Minor, that was the one with the transfer of funds because of money over. I see that I'm out of time. If there were any...
They're saying that, Minor, it was all on the defendants, that Minor could have started if they had just transferred the funds for this issue, but that they held it up because they wanted Minor to do something else, and that didn't have the approval, and that's on your client. So what do you say to that?
Well, I don't believe that they were trying to hold it. You're saying they were trying to hold it up because of a second issue?
Yeah, the brief from the other side says that your clients wanted to hire Minor for 2 different matters. One was to clear these warrants, and the other was some other issue. And that there was already a trustee approval for the funds for Project 1, clearing the warrants, but that there wasn't for Project 2, so the money didn't get transferred, and that delayed clearing the warrants, which meant your clients didn't comply with the court order.
I believe when the trust funds were approved for this matter, because that's where they had to get the money in order to retain counsel, okay? And I will say candidly to the court that I have had the same issues with money internationally. It's an issue. Now, but ultimately, all of that may smack. One might say, is that bad faith? Are they trying? They are trying. The question is, was there a less intrusive result? There would have been. I would have moved to stay all of the discovery pending the resolution of the criminal case. Instead, the discovery should have been stayed pending the warrants. That was a bare minimum. Instead, they don't get their day in court on these salacious allegations. I find that a miscarriage of justice, and we respectfully request that it be reversed and remanded for trial. Thank you, Your Honor.
I have one other question. In your appellate brief, you argue that the intentional infliction damages, or at least a portion of them, are barred by the statute of limitations. Was that argued anywhere to Judge Wilkins before, during, or after the assessment of damages hearing? I couldn't find it.
I'm sorry. I do not know. I am successor appellate counsel. I am not 100% sure on that specific question, but what I can say is that the issue was raised in a Rule 12 motion and raised in the motion related to the assessment of damages, the opposition to the assessment, which is, I believe, the critical time to so raise it. If there's a question of whether that was raised appropriately.
Thank you.
Thank you, Your Honor. Are there any other questions? Thank you.
Just wait a minute. All right, thank you.
Thank you, Your Honor.
Good morning, members of the panel. Maria Davis on behalf of Jace Guattari. I want to address one thing right off the bat. There is no allegation or no credible allegation that my partner, Howard Cooper, ever tried to use the criminal process to get any sort of civil result. I will say I've been on this case since the beginning with him. I've worked every bit of this with him, and that just does not exist. I will say that Professor Hay has submitted many conflicting affidavits over the course of this, as it seems like his relationship with the defendants fluctuates and changes. But I did want to address that right off the top. Now, in terms of the deposition notices, you had the question of when were the deposition notices first issued. The first ones were issued in September 2018. They were reissued in December 2018. There was a representation from defendant's counsel that she would provide new dates by January 4th. She didn't, so they were reissued again on January 3rd. They were renoticed for January 24th, and on January 18th, we were told of the motion to dismiss. And so there were a number of deposition notices that were issued during that time period.
So you're saying there were some notices before there was a motion to dismiss?
Yes.
Okay, then there's a period where there's a motion to dismiss pending. When does that end?
So the motion to dismiss, I believe, was filed in February. It wasn't decided until, I believe it was June. The motion to stay was never decided. There was a motion to stay that was filed. It was never decided. We reissued the notices in June. At this time, my understanding is that there was no knowledge of the criminal arrest warrants, but there was still resistance to appearing. And essentially, the position that defendants took, first, they wanted to pick the date. We said, that's fine. Give us a date that works for you before August 5th. Never got back to us, so we reissued again. And then it came up that they didn't want to appear unless we would agree that we wouldn't ask broad topics of questions. And these were topics that went directly to the heart of our allegations. And we didn't agree to that. So ultimately, we get to August, file the motion to compel, and this is the first time that it comes to light that there are these arrest warrants.
When did it come to light that there were the arrest warrants?
So it was in the motion to compel briefing. I'm not entirely sure who raised it first. I know I definitely researched the defendants when I was prepping for their depositions. Both parties addressed it, I believe. My understanding is that they were very simple, basic arrest warrants. It was for not appearing in a district court case. We did go forward with the motion to compel, and Judge Henry essentially said, look it, I understand you have these warrants.
Different Judge Henry.
We have these warrants, we'll give you 60 days to appear. And my understanding from representations made at that hearing is they said they already had representation in the form of Attorney Fuller. After this, it was basically just representation after representation of, we have a lawyer, they're working on it. We have a lawyer, they're working on it. And as it turns out, we get to the end of this period, and they don't have a lawyer. They've never hired anyone. According to the briefing here, they got in contact with 4 criminal defense lawyers. And the argument was essentially that everyone was conflicted because Bruce Hay works at Harvard, and so they couldn't get a criminal defense lawyer. Now, in terms of Attorney Minor, there were numerous representations to Judge Green that she had been retained. She was working on this, it was active. It's not just the lawyers, the defendants themselves signed essentially affidavits. They signed the motion papers saying, we hired her, we've retained her, she's working on it. There was also representations to the court that the attorney said, my clients are telling me they've hired her, she's working on it, we'll be done. And based on that first, so there was a default motion that was filed. In October, the court decided it wouldn't issue a default because they said specifically, we will be here for depositions by November 30th. Now, it was a difficult hearing because essentially it was the same representations that somebody has been hired, they're working on this, here's their affidavit saying they're working on it, here's the defendant's signature saying we paid them. And Judge Green very rightfully said, look this has been going on for a long time. Go out in the hall, call your clients. I want an update. And opposing counsel had to come back and say, they haven't actually hired anyone yet, but they're going to. And so this was sort of the course that it took for a period of months of them saying they were hiring Attorney Minor, they're going to, but then never paying the retainer. And I submit to you, the fact that they chose not to pay her and instead wait to see if they could get more money from their trust to try to do something else too, that's not a good faith effort. Ultimately, they didn't meet the November 30th deadline. Their defense was, well, she's really going to be retained now. She's going forward. We have Attorney Minor on this. At this point, that is the point that the court entered the defaults. And we would submit to you that that was entirely appropriate. I think we all agree that it's an abuse of discretion standard to overturn Judge Green's ruling. And here she had ample reason to enter the defaults.
So one of the arguments that the defendants make is then you sat around for 17 months, so you could have just let this happen, and we prefer resolution on the merits. So what was the, hurry up and get them jammed up, and then now we're going to wait for a very long time?
So I would say 2 things. The first is COVID happened. And so there was a shift sort of as everyone moved back to their home offices. There's a change in the landscape, and things did quiet down for quite some time. I will also say this was truly a very traumatic experience for my client. And while there is some finality, and COVID was going on, and there's a lot going on, we did wait. At the same time, that didn't bar defendants from moving to vacate the default at that time. In looking whether or not a default should be vacated, one question is, did they move on a timely basis? Here they're saying the arrest warrants were lifted, and I believe it was April of 2020. Had they moved then, it would have been a couple of months after the fact. I think that's a much more...
Actually, from what I can tell from the record, Hay came forward in February of 2020, which would have been before the pandemic, but that it actually, this does actually seem significant to me now that I'm actually saying it out loud, that it took 4 months from when he came forward for the charges to be dismissed. I'm unclear, but if he came forward, that sounds like maybe the court was informed. So, so if it took the court 4 months when I mean, I don't know, maybe I'm misreading this, but.
So it sounds to me like what happened was, as opposed to somebody going in and moving to vacate the arrest warrants, he essentially went in as the complaining witness. And, again, at the beginning of the pandemic here, he went in and said,
Well, now that wasn't really, everything happened around March 13th, 2020. So he comes forward in February. So we all know bad stuff's happening, but we have no idea how bad it was going to be.
It was a surprise. So I would say, Your Honor, I think here, again, where he's coming in as the complaining witness as opposed to coming in with a motion to vacate with the actual bases.
Well, I know, but I mean, my God, if it takes 4 months when the only complaining witness comes in and says, oops, my bad,
so if
as opposed to when the defendant comes in and says, oh, here, I have this evidence.
So if you look at Attorney Minor's affidavit, one of the representations that she makes in that, which I do think is very important, as of October 17th, which is when she says that she wrote this affidavit, her view was that if we file, if we file these now, if you retain me now, we can be done by November 30th. And as Your Honor pointed out, she is a very experienced lawyer. Tracy Minor knows what she's doing.
Right, but yes, and I would agree with that too. But then are we punishing the defendants for her optimism?
I don't think we're punishing them for her optimism. I think we are telling litigants that you can't make misrepresentations to the court about the actions that you're taking. Here again, it's not just that they weren't getting someone. It's that, as they say in their own papers, they contacted 4 lawyers over the course of a month to try to find someone, and then repeatedly told the court they were doing something different. They were representing that they were being diligent. And here, I would submit that particularly where you have not 1, but 2 court orders telling you to appear, and the second one is based on your representations that you can be there by November 30th based on your conversation. And I will also submit, Your Honor, I think it would be a very different circumstance if they had retained Attorney Minor and she went forward and couldn't get it done by the 30th. I don't know that we would be here, but here they didn't retain her. They chose instead not to retain her and to wait to see if they could get more money for a separate matter. And I will also say, in terms of the document responses, they did produce documents. So we served document responses, I believe it was in January. Following the motion to compel, they had 14 days to comply. They did submit very limited documents at that time.
Did they submit interrogatory responses?
I don't believe we served interrogatories at that time.
Okay.
So the plaintiff experienced anxiety when he was told that he was going to be the father of a child, and he knew the cause of that anxiety was that he would be the father of a child with a relative stranger. Why doesn't that constitute sufficient awareness of harm to make the claim accrue?
So I think that Judge Wilkins' decision on this is very apt. This is a circumstance where he thought he had a consensual sexual encounter. He thought it led to an unplanned pregnancy. And while he was upset, he stepped up immediately. He said, all right, I want to be involved. It wasn't until later, and I don't want to get into all the backstory. You have the facts as we lay them out in our brief. But it wasn't until later that he learned that many of the things he had been told at the time were just untrue, but also they showed that there was a scheme. The fact that
I think what he's trying to get at, and is something I'm puzzled by too, is like there could be a new act that would re-trigger. So the question is a harm known and it got worse, in which case they're barred by the statute of limitations, or was there a new act? So the telling him about the videotape seems to me to be a new act, but that's covered by the Privacy Act violation, and we're really talking about the $20,000. So what was that keyed to that was within the statute of limitations that was a new act?
So I would say that's twofold. First of all, the new act, so under the law, you have to have first knowledge or sufficient notice that you were harmed, and second, what the cause of harm is. Here, the fact that he learned of an unplanned pregnancy, that's not harm. It might have been surprising, it might have been something he wasn't planning on, but it wasn't harm. Learning that...
So he suffered emotional distress, but that wasn't what would you say, legally cognizable harm?
I agree with that, yes. There were distinct events, though, when he found out that this is a person who said he had to be the dad because she'd never been with anyone else. Well, it turned out the person that interviewed him was her wife. So things like this, the fact that there was the sex tape, which I understand that's the Privacy Act, but the blackmailing of him with the sex tape saying, don't bring your litigation or this is coming out, that's separate from the Privacy Act. And so I would submit that it's sort of this whole plethora of circumstances that show that there was this nefarious scheme. This isn't a situation where there's continuous acts leading to ongoing harm. There was an unplanned pregnancy, that's one thing. Finding out that you've been targeted, that there's a sex tape, that you're being told it could be distributed, that's a very different thing.
And when was he, I'm trying to keep this not so salacious, but so when did he find out he was arguably targeted in a scheme similar to other people?
Sure. So in terms of finding out and starting to realize the deceptions and the scheme, he hired a private investigator in the.
No, but when was that?
The beginning of 2016. So it was January 2016. There was some resistance to a paternity test. He found out that he was not the child's father in April of 2016. Shortly after that, he had said, I'm going to bring a lawsuit for my legal fees. I've accrued a lot of legal fees, and that's when the tape was mailed or produced, along with the claim that they would use it against him. And so it was really in that time period between January 2016 and April 2016 where all of these events accrued.
Was the issue of the limitations period argued at any time around the damages hearing?
I don't believe so. I know it was raised in a motion to dismiss, which was denied, that he hasn't been appealed from.
As I read that motion to dismiss, it didn't even deal with the limitations issue. It just said the allegations of the complaint are sufficient under Iannaquino. So it
Correct.
wasn't as if the limitations period issue had been resolved.
Correct. And so, my recollection is it was not argued at all in terms of the damage assessment hearing. One more thing before I forget about it. In terms of us having not refuted the Hay affidavit, any allegations in there, that was actually extensively litigated in motions to have us both removed from the case. There was various motions that was passed on a great deal.
Turning, though, to paragraph 17 of that, which is on record, appendix 808, there's a sentence that one could read. It's what it says is, I also provided the Cambridge police with the wrong address for the Schumans, ensuring that, there's no punctuation here, ensuring that they would not get notice of any hearings on the matter, thereby assuring their defaults. One could read that to say he intentionally did it, but it doesn't actually use the word intentionally. Do we construe this in the light most favorable to anybody here?
No, I think it's one of many affidavits that he's filed. It's not clear. I agree that it's sort of cagily written, so it's not entirely clear what it says. I will say there's nothing in the record that relates to whether he did something on purpose or whether it was accidental.
I hear what you're saying, that the affidavit is cagily written, but on the other hand, it says lots of things that make him look very, very bad.
I would submit to your honor, we do get into some of this detail in our factual recitation, which I don't necessarily want to get to on the record, but I would submit that if you look at the things that he has submitted, we didn't necessarily know that up until later, but he ended up, we also have an affidavit he provided on his own that says pretty much the opposite in terms of the defendants. So I would submit that to the extent he's writing things to now support people that he was in litigation with, there's a lot of conflicting information about attorney or Professor Hay.
All right, thank you very much.
Thank you.
The case is submitted, and we understand your positions. That concludes our sitting for today, so I wanted to thank our staff for all the work they've done, as we had a lot of last-minute practice and continuances and such. I really appreciate your help. We're going to you're free to go. We've got some students here, so I think we're just going to put our stuff in the back, and then we'll come out and talk to the students.
Put on rise, please. Court is now in recess.